Good afternoon. Welcome to the LA County Bar's webinar series. This is going to be the first in a whole ton of great webinars. You're going to hear a bunch from Abbas Hadjian, from Tigran Palian, Brian Lepak, and then of course from our superstars, supervising family law judge Lawrence Riff, and of course Ruth Gonzalez from the LA Superior Court System today. And so we are looking forward to an amazing program. Just to give everybody a heads up, this is probably going to be the best attended program that we have of the year. Last time I counted, we have plus 400 people signed up for it, and I bet we're over 500 people that are signed up for it right now. So this is going to be a spectacular program. I'm Steve Mendel. I'm chair this year of the LA County Bar Family Law section. We call ourselves FlexCom, Family Law Executive Committee. If you're interested in participating on FlexCom, we have a million great committees. All of the programs that we put on, such as this program, or the Child Custody Colloquium, or the Symposium, or the Trope Institute, any of these programs all have little committees. Plus, we have a million committees that deal with legislation and other issues related to family law practice in Los Angeles and throughout the state. If you're interested in joining one of the committees, go to the LA County Bar website, look up the section Family Law, look up Executive Committee, and talk to any of the Executive Committee members. We're all here to help you and be your guides through FlexCom. Before I turn the ball over to Abbas Hadjian, I just want to say thank you to all of our sponsors. You can see the sponsors on the bottom of our sponsor page. But one thing that I'd like to point out to everybody is that the official LA County Bar e-filing sponsor is First Legal. And if you have any questions regarding First Legal, the team at First Legal are there always to help. In the meantime, I'm going to kick the ball over to Abbas Hadjian, the FlexCom chair-elect. That means he's going to be the chair, hopefully starting on July 1st, and I will be the immediate past chair, which is Paula Kane this year, for those of you who know Paula. And without further ado, Mr. Hadjian, it's your show.
Good morning. Thank you, Your Honor. Thank you, participants. I know that many judicial officers, they are sitting there as a attendee. Welcome to all of you, and Director Gonzalez for participating in today's program. The first few minutes of the program, I would like to have the chance of introducing to you the FLAT program, Family Law Advocacy Training, which starts officially next Wednesday, November 10 at 12 noon for 16 sessions. 4 points I would like to raise with respect to that program. Philosophically, the FLAT program will try to prepare and present the new generation of family law practitioners. All of us, all of these 300 or 400 people that we are participating in the program today, I dare to say that none of us went to a special family law school in order to become family law attorney. We became all family law attorney by accident. We are accidental attorneys. We are a relative, a friend, or somehow, for some reason, we were introduced to family law attorney, and by trial or error, we found out how to be family law attorney, or to be a specialist, or to be a judge for that matter. For the first time in the history of this state, not only city or county, there is an organization which provides us, people, all of you, an opportunity to start becoming a family law attorney and understand what this family law attorney is, from filing petition to end of appeal. Appeal also part of this training program. This is number one. Number two, as of this moment, 20 judicial officers, which they all are busy like Judge Riff, and more than 30 family law practitioners like Brian, like Tigran, like Steve Mendel, have volunteered to act as moderator, as a speakers, as support for the program, which tells us we are doing something really right. As of this moment, it is hard to believe, 9 family law entities, either directly attorneys, service providers, or experts They have volunteered without knowing what we are going to do to put their support and money as the sponsors of the program. Thank you to all 9 of you, which if Araceli can show the flyer, we will be able to see them. And also I know about 10 more entities that they are studying it to join us. Lastly, to all of you that are listening to this program, this flat program is for you. If you are a partner in a big law firm like Steve Mendel, you will benefit from it. If you are a paralegal in a small firm like me, you will benefit from it. If you are a law student hoping to start to go to family law practice, imagine this. By next June, you can put in the resume that I am graduate of LACBA's family law advocacy training. And guess who's gonna hire you? Mr. Steve Mendel. Many other family law entities that the first condition of hiring any family law attorney, having 3 to 5 years of experience of family law. This program is for you. The price structure for this program is the way that anybody can afford it. And we are hoping that with help of LACBA to make it even easier for attorneys who are pro bono, work a pro bono system to participate in the program. On this note, I would like to introduce to you my friend and colleague, Mr. Brian Lepak. Brian is the co-chair of CLE, which is the plan that we have for the next 3 years, 2021-22, next year and following year. The 3 people who will lead this organization, we will have a coordinated, harmonized CLE program. And I will ask Brian to take it from here. And thank you all for, again, participating. At 12:15 or maybe 12:20, we come back to start the program with Judge Riff. Brian?
I think we're actually going to tip it over to Tigran first, and then I will follow Tigran. So Tigran will tell us a little more about FLAT and other programs that we have for LACBA for CLE.
Sure. Well, I'm very excited about introducing this program. FLAT, as you heard Abbas say, it stands for Family Law Advocacy Training. What's really unique about this program is it's a comprehensive series of 16 modules, twice a month during the lunch hour. And I have to thank Abbas because the program is really a product of his vision. And it consists of 4 chapters, if you will, starting from commencing the case and to trial, to discovery, to appeal. If you are a partner at a firm, or if you're a young associate yourself, this is the perfect comprehensive training where you will have a linear perspective of a case from its inception, starting with the client interview, all the way to judgment to appeal. And to get that level of training from a wide variety of professionals and a judicial officer on each panel, that's what we have to offer with this program that I think is truly unique and accessible. And in terms of the starting point of that will be in November, on November 10th. We have David Yamamoto, Judge Diana Gould-Saltman, and our own very own Abbas, starting with the initial client interview and filing the petition. And essentially, the program will continue from that point all the way through June, consisting of 16 sessions, each of those 4 chapters that I described divided into 4 modules. Before I hand it over to Brian, I did want to make a quick announcement. We have our Family Law Symposium on May 14th. And this will be the first, very excited to announce, it will be the first official in-person major CLE since our last 2 years of dealing with a pandemic. And Brian, I'll give it to you now.
All right, thank you, Tigran. I know you guys are here to hear Judge Riff and Ms. Gonzalez, so I'll be quick about this and turn the program over to them very shortly. But I want to let you guys know that Steve Mendel, the current chair of the family law section for LACBA, the incoming chair, Abbas Hajian, and the vice chair, Steve Kowalty, have gotten together and want to focus on CLE. Thus, not only am I a co-chair, and Tigran, a co-chair of the CLE committee, but we also have Stephen Yoda, who's a co-chair. So we have 3 people who are ahead of this CLE committee, because we want to focus on CLE for this section, because we want to be better attorneys. We want to help each other improve in our practice, not only to make more money, but so that we can better communicate with one another, which will help us to try to settle cases rather than litigate cases, which I know is a focus for Judge Riff on trying to make us better at how we could communicate better to resolve cases and make it more affordable for our clients. I want to let you know the future of CLE is obviously we're starting out with flat with this very ambitious program, and I have to thank Judge Riff for that, because he's been outstanding in getting us judicial officers to appear on every single one of those panels, and that we will have a former chair of the family law section on each one of those panels. And I want to thank them for their participation in flat. And then we'll have experts on various topics that are going to be discussed that time. So this is our first ambition in trying to make us better as family law attorneys with these programs. We're not going to forget, after this flat is done, to have more programs on a frequent basis for CLE for LACBA. We will still do Zoom programs because we know how convenient that is for you to do them by lunch and not have to make your appearance. So if you have ideas that you want us to talk about, we want to talk about current cases. We want to get you introduced to new judges that are being brought on. But if you have any ideas, please let us know. You can email any one of us on this committee to talk about programs we want to do for you. And that's our goal at LACBA Family Law Section, to service you better on your educational needs. And with that, I will turn the program over to Judge Riff and Ms. Gonzalez.
Well, thank you, Brian, Tigran, Steve, and Abbas. So I'm going to put my 2 cents in on this flat program too, in terms of an endorsement. I'm pretty excited about it. And when I have the chance to suggest some judges to participate, I signed myself up for, frankly, as many as Brian would let me. And the reason for that is that I do think it will benefit all of us to focus on some more and more of the fundamentals of trial practice in family court. I know you know that's something I care about, because somehow during the minors counsel training, when Carrie Pines and I were doing a session on emojis, I ended up lecturing on how to qualify an expert in family court. So I'm looking forward to flat. Now, let's turn to today's business. Has anybody ever had the experience in a dream where you walk into a college class and the professor says, "Welcome to Econ 102. Of course, you've already taken Econ 101, so we're going to assume you know all that." Well, that is not exactly where we are today, but this is like family law e-filing 1.5 in this sense. Ms. Gonzalez and I, and Presiding Judge Taylor, and CEO Sherry Carter gave a pretty comprehensive overview of e-filing in family law back on October 1, 2021. Many slides, many words were spoken, and I hope very much that you have all watched that, because that is the basic overview that that you all need. Now, I'm assuming of the 374 people who have logged in on this, maybe half have said, "Oh, I meant to do that. I meant to get around to that, but I have not." So what Anna, Ruth, and I have decided to try to do today is to reprise, I think it's reprise, the key elements of that overview. We're going to be drawing from some of the slides, not all of them, from that overview. We're going to embellish what we talked about, and we're going to expand on certain topics based on the very many questions that we've received from you all since October 1. I want to say that if you want to see the October 1 video, it's available. It's on our website. I urge you to do it. Also on our website, When you go to family law and you go to e-filing, you will see frequently asked questions. As of this morning, there are 86 of them. And probably if you have a question, your question is one of those 86. So that is the aim of what we're doing. Let me say a word about Anna Ruth Gonzalez, who I think has some introductory comments as well. Those of you who don't know her, she is the director of family law, probate, and mental health here at our court. So court operations in our 4,600 employee, $900 million budget, 37 courthouse court system. Court operations is a sophisticated logistics supply chain. We now know what happens when supply chains get screwed up. It's all about the news. It is Anna Ruth's job, together with scores and scores, hundreds of other people working with her, to keep the supply chain moving in family law. Anna Ruth has many years of experience in court operations, both here and in Orange County. Anna Ruth reports directly into the executive office of our court, Sherry Carter and Denny Butler, and hundreds of employees report directly and indirectly to Anna Ruth. Our family community, I should say, should consider themselves blessed, and we should count our blessings that Anna Ruth is our director. I really mean that. Okay, I want to encourage you all to read the general order of September 17, 2021 regarding mandatory e-filing in family law. Where do I find that, Judge Riff? Where's the general order? The hint is everything's on the website, www.lacourt.org, okay? Now, the general order, which I hope you read, reflects the California Rules of Court commencing with CRC 2.250. You've probably never had any reason to read that set of court rules, but now you do, because in 12 days, you will be mandatorily using e-filing in family court. And if you show up at the clerk's office with a piece of paper and say, I would like to file this the way I've been doing for the last 40 years, you may have a rude awakening, okay? So consistent with those court rules, e-filing will be mandatory in family law for represented parties, including limited scope representation. E-filing is optional for self-represented litigants. Now, there are several major exceptions to that, but I want to highlight one right now. Restraining order applications that are filed in the Family Law Division, which are virtually everything except for criminal restraining orders. Those applications and responses filed in the Family Law Division may be filed electronically or conventionally in paper, whether the party is represented or not. Major exception. So, Anna Ruth, would you like to make any introductory comments?
Sure. Thank you, Judge Riff, first of all, for that very kind introduction, and good afternoon to you all. As Judge Riff noted, I am the director for what we call Region 2 of Los Angeles Superior Court, which does include family law, probate, and mental health, and includes the clerk's office and courtroom operations, as well as some of the support functions for these litigations, like self-help centers, family court services, and the Office of the Family Law Facilitator, just to give you a few examples of those support functions within family law. So part of my job is to ensure that the daily operations and services that the court offers are understood and implemented in a way that continues to deliver access to the courts and maintains procedural fairness for litigants. Of course, none of what I do is possible without the great leadership of our judicial partners in the court. And it has been my great pleasure to work with amazing supervising judges in family law who do care about the important work and the impact on families that our work has, like Judge Riff, who has guided the progress and the direction for family law as its most recent supervising judge. In this past year, as we have navigated the impact of this worldwide pandemic, the court has implemented many services it did not previously offer. And that includes scheduling of appointments to file family law clerk's office documents to promote social distancing, provided drop boxes outside courthouse locations. We adopted interim resource accounts for submission of time-sensitive documents. We implemented remote appearance options for hearings, scheduled remote mediations for parents, and most recently deployed chatbots for frequently asked questions from the public. These services were implemented while dealing with challenges such as shortages due to flexible staffing options necessitated from kids being out of school, sometimes due to quarantine retirements or simply based on symptom check protocols for staff. Nonetheless, during this time, we have reinvigorated our commitment to deliver electronic filing to you all, such as is available in civil and in probate. And today, I welcome the opportunity to talk with you about our initial implementation for family law e-filing. So if we can start that slideshow, we'll just dive right in.
So Abbas, we want you to go to slide 8, please.
Show slide 8.
Please, yes. So while you do that, I'll go ahead and just kind of recap on the general order that Judge Riff mentioned. It is posted on the website, and some of the takeaways from that order include that family law e-filing will be rolled out in 2 phases. The first phase is the mandatory e-filing for attorneys, including limited scope representation attorneys and court-appointed counsel. We will start e-filing as of November 15th, 2021. As of this date, the e-filing will be the only option for electronic submissions. So also, as has been noted in the past, no more fax filing and no more emailing of documents to the court through resource accounts. So all electronic submissions will be through the e-filing system. Self-represented litigants have the option to e-file their documents as of November 15th, but are not required to do so.
Shall we go to slide 10?
Not yet.
Oh, not yet, okay.
Yeah.
All right.
Okay. We, as Judge Riff mentioned, we do have a list of exempt documents. Some of the ones I'd like to highlight are that we are not e-filing yet on AB1058 cases. We are not e-filing judgments or challenges to judicial officers. We've had some questions about the challenges to judicial officers and why not e-file. Sometimes these challenges require service on the judge themselves, or can be submitted at the time that a hearing is sent out on the day of the hearing. And so for those reasons, challenges to judicial officers may not be e-filed. Also exempt are exhibits for evidentiary hearings. Those should be dropped off to the courthouse before your hearing. And the full list of exemptions is included in the general order. So we talked about that being phase 1. Phase 2, what is that? So we do expect to roll out a second phase in the first quarter of 2022. Phase 2 will include the processing of orders and judgments electronically. We will be able to route them for signature internally and to return them back to you through an electronic process. So until then, proposed orders will be mailed back to you and imaged. And we point out the imaging part because once imaged, they become available through your attorney portal, as well as the public portals in the courthouse locations. For now, time-sensitive orders like ex parte orders will be emailed to you, as we do realize that mail doesn't make sense for those types of orders. And we had a question about AB 1058 filings. When would those be eligible for e-filing? We don't have a date certain, but we do expect that in 2022, we will also roll out e-filing for child support cases. And part of the delay is that we do have to interface with the state DCSS electronic systems for their filings. So that caused a little bit of a delay for the AB 1058 cases. Okay, slide 10, please.
Maybe we should help Abbas to put on a full screen for this. Either you or Araceli can comment and help him. There you go. To the right, one more over.
And also, Abbas, if you just kick the slideshow, it'll let you move between the screens. So if you hit the slideshow up on the top portion of it, it'll let you to your right. There you go. One more over. No. That's going to start from the beginning, but you could start there if you wanted. And then just click to slide, whatever slide you're on.
Anna Ruth, before you hit slide 10, let me just make sure that a very fundamental concept is understood that you just addressed is between phase 1 and phase 2. Why are we doing that? Basically, the difference between phase 1 and phase 2, basically, is that documents that need to be received and processed by the court, which will need a judicial signature, we are not yet receiving by e-filing. There is a workflow software loop still being created that will, when we roll out phase 2, close that gap, at which point those proposed orders will be received by e-filing as well. I know Anna Ruth said that. I just wanted to highlight it. Okay, Anna Ruth.
Okay, let me make one little point of clarification there. So for proposed orders, we will accept them via e-filing on phase 1, but we cannot return them to you electronically as part of phase 1 because of that workflow that Judge Riff just mentioned. So we'll take them, but we are returning them to you by mail. Okay, so just to give you a big picture snapshot of the e-filing process, you'll see here the filing starts with the filer, which is you or your office. The filer will then, there you go. The filer will be required to register with an electronic filing service provider. There are many to choose from. And your EFSP vendor will help with formatting and processing the filing fees, and then transmit your document in a ready state to the electronic filing management system. The EFSP is the liaison for your filing between the court and you as the filer. Again, they process payment, they help get your document in ready state to submit to the court, and they can help troubleshoot technical issues. You as the filer will register with the EFSP, and you will use their filing portal to submit your filing. Again, you can choose from a variety of EFSP, and all of them will be submitting to one electronic filing management system where the court will then grab those filings, review them, and accept them. There are some questions that we saw inquiring as to why you cannot file directly with the court. The court does not have an e-filing portal to process payments or an e-filing management system, which offers the functionality that the Odyssey Filing Service system offers for us to review those filings. The California Rules of Court have authorized us to contract with EFSPs for the e-filing process in California, and the court has implemented the use of EFSPs to pass on the filings to the court once verified that they are in ready state. Next slide. So once the clerk accepts the filing from the e-filing management system, your document is accepted into the court CMS, where it does become part of the court record. So just a point of caution, remember that just because you submitted the document doesn't mean that the judge can see it. The clerk has to accept the filing, same as if you had an over-the-counter clerk accept your filing. Once accepted, then the document will be available as part of the record. And in the prior slide, you saw that on our website, you have the option to pick your EFSP. This is on the bottom right. This is what the website looks like. If you just click on one of those logos, you'll be able to see the services that each of those providers offers. These vendors have been certified by Tyler Technologies to deliver the document to the court in a ready state, and the court then again picks them up for review. This is generally the same list of providers currently available to file in probate as well as in civil. So if you're registered with one of these EFSPs already, you can use them without an issue for submitting your family law documents as well. The registration requirements with these vendors are simple. You have to have a valid email address. We need this information to send conformed copies back to you. And then once you register with one EFSP, you can actually use the same username and password for any other EFSPs. So registering with one does not lock you into a vendor arrangement with that one. You can switch at any time. Next slide, please. Actually, we can go to 12, please, slide 12. Okay, so the logo on top of this slide that you see that says e-filing, you will find that on the homepage of the court's website. You will also find that on the family law homepage. When you click there, then select family law, you will be able to see a whole host of resources that Judge Riff mentioned. You'll find FAQs, the general order, the video, the list of documents that may be e-filed, among other things. So just remember to go there and take a look at our resources. Okay, one typical question we get about e-filing is whether EFSPs will honor fee waivers, and the answer is yes. There are EFSPs who will honor fee waivers, including their cost to submit your document if you have or are submitting a fee waiver. For domestic violence submissions, we ask that you select the fee waiver payment option so that the court can also waive the $225 transaction fee, and so that the EFSPs can treat this as a no fee document. So just a point there to please mark your DVs with the fee waiver option. The court does not publish a list of EFSPs who waive fees nor promote the use of any EFSP over another. Your office will need to determine what EFSP better suits your needs based on their service model. Service models range from these EFSPs. Some offer subscription services for high volume filers. Others offer e-service as an optional service to other parties, and others are just transaction based. So you will need to do the research and make your selection for your EFSP that best suits your firm. Okay, slide 13, please. So I'm just gonna recap for you that you are required to register with an EFSP. You will then log into their filing portal and enter information about your filing. For example, what courthouse you're trying to file in, what document you're trying to file, the case number. Those are just some examples. Most will require you to enter this type of information into the portal, but some offer additional convenience to do this for you. For example, they may offer to have you email them the documents, and then they prep them for e-filing and submit them through a portal for you. Again, different service models are available depending on the EFSP that you select. For most, you will then enter your payment information or indicate if you have a fee waiver, and then you will attach your PDF document to be filed with the court and then select to submit your filing. Thereafter, you will be able to go into that same portal and check for past filings or receive confirmed copies through the portal at any time. Okay. Judge Riff?
Thank you. Again, I want to make sure that some of the basic headline points are not missed here. And when I misstate them, Anna Ruth will correct me, I'm sure. But here's what I want to make sure everybody gets. So your EFSB is going to charge you a fee for its services. That money does not go to the court. All right. The court is also going to charge $2.25 for an envelope transaction. Now, there's a new lingo, there's a new vocabulary. Please read the general order so that you can sprechen the Deutsch, as it were. Okay. Here is a point that Anna Ruth made that I want to make sure is not lost. At the request of several in the community, and our friends in the Family Law Coalition in particular, we are going to waive the $2.25 fee that does go to the court in restraining order matters. And what Anna Ruth was saying was, in order to get that, we're going to ask you to check the fee waiver
Payment
box.
option. Yeah.
Is that right, Anna Rose? Did I get that right?
That's right. Right.
Okay. All right. So please go to slide 17, Abbas. Okay. So your filings are going to look different when you get them back from us once e-filed, okay? I know you're normally used to seeing the conform stamp and things like that. That's not what you're going to see. You're going to see what we call a filing ribbon. And we, in the longer presentation that I'm urging you to watch, we have some slides of what that looks like. But imagine, if you will, it's a ribbon that runs along the top of the document, not too dissimilar from, say, you know, a fax legend from the old days. The filing ribbon will contain the case number and the case assignment to a judicial officer. There's not going to be a separate notice of case assignment for e-filed petitions. But filings made conventionally in paper will still result in our generating a paper case assignment by the clerk's office, okay? So if you want to be exercising your 170.6, look at the ribbon, see who your judge is. There are a collection of court-generated as opposed to filer-generated documents that are also going to be returned to the filer from the court's resource account. What am I talking about? So, for example, orders for mediation and various supervising judges' orders regarding financial documents and in dissolution matters, those kinds of things are generated by the court, not by you all. And we will be sending them to you, not back through your EFSB, but by our email resource account. So the point is, you'll be getting some documents from us as well as from your EFSP. Now I want to talk about something really important, the scheduling of RFOs. I know this is a big deal. We've got a lot of questions on this. So let's talk about RFOs, motions, and OSCs that I'm going to collectively call RFOs. When you submit your RFO for filing, the e-filing system will automatically generate a hearing date based on the next available date in your home court. The range should be between about 45 and 120 days. You can get some insight as to when your RFO is likely to be set by going where? To the website, because we do publish now when the various home courts are setting next RFOs. So at least you'll know the week in which it's likely to get set. Some departments have various settings during the week. Some may set at 8:30, 10:30, and 1:30, some only at 8:30, some at 8:30 and 1:30. Whatever the deal is for your home court, the next available setting will be automatically generated. Go to slide 18, please. Okay, now, many of you have asked, well, can I somehow get a convenient date at the front end? There's some days I know I won't be available. I'm on vacation, I'm in trial, whatever. And in the good old days, I would put on the buck slip and hand it to my tattooed messenger for his or her ride down on the bicycle to the clerk's office. I am unavailable on these days, right? Is there a way that we can do that now? And the answer is unfortunately no. There is not a way to do that. And for those of you who are feeling bad about that, I want to tell you that at least in theory, for the past period of time, meaningful period of time, our filing clerks' windows have been instructed not to entertain those requests on those buck slips. I can't guarantee, nor can Anna Ruth, what's going on in 12 different courthouses with multiple employees, but in theory, this does not represent a change in policy. But what we do want to introduce is a new way of obtaining a continued or changed hearing date once your hearing date has been automatically generated and stamped on your document. So we have developed a new form that we are showing you in this slide, not yet approved, but it will be by the time this rolls out in 12 days. This is a form that you can use to request a different continued hearing date. Because the government code requires it, friends, we are going to charge a $20 fee for the submission of this form. There are four main things we want you to know about this method of obtaining a different hearing date. First, this method may be used so long as the request, this form, so long it is submitted at least 45 days before the scheduled hearing date. So I need a continuance a week before the hearing. This is not the method to use. Second thing, if your RFO has been served on the other party or parties, this form operates as a stipulation and all parties must execute it. Third, you must supply to us at least 3 dates, at least that are good for you, 3 dates, at least 35 days after the currently scheduled hearing. Okay? Now, if the thing's been served, then you all have to agree upon those dates. Fourth thing I want you to know, it will be our practice that administratively, we're going to approve a request submitted on this form that meets the criteria I just outlined for any first-time continuance, okay? But any continuance beyond a first continuance has to go to the judicial officer. And one of the questions on this form is, has this RFO been continued in the past? Now, what are you going to do if you want to seek a continuance sooner than 45 days from the scheduled hearing date? Okay, the 10 days in advance, or what we sometimes see is the day before the hearing. Gee, we want a continuance, Judge. Our best advice to you, how to seek a continuance is to bring an ex parte application or appear at the hearing and ask for it. Now, what we're suggesting you not do, we're trying to talk you out of this. Please don't call the department and ask. That has been a source of great frustration for you. We know you call and nobody answers. That frequently happens at mosque for reasons we don't have time to cover. Many of our departments, and I know this because I did a survey of our judicial officers, they will not entertain a telephonic request to continue a hearing date. Some do, some don't. But the bottom line is, we think that it's an ill-advised way to try to get your continuance. Please do it a different way. Okay, moving on. I see how fast the clock is moving. Slide 21, please, Abbas. Okay. So e-filing is mandatory for represented parties, but there is a meaningfully long list of documents for which are exempt, which means cannot be filed. It's not optional, they can't be filed or presented by e-filing. This is a partial list, and I just want to highlight them to kind of burn it into your head at the front end here. 170.6s, 170.1s, 170.3. Anna Ruth commented on that as to why often they need to be personally served on the judge or the judge's clerk. Trial and evidentiary hearing exhibits, 500 exhibits. We do not want you to e-file those. Somebody asked a question, well, what about a trial exhibit that's incorporated by reference in an RFO as an exhibit? Of course, that's fine. But your proposed trial exhibits that you're going to be using at your 217 hearing or your trial, do not e-file those, lodge them, bring them to your hearing. Bonds and undertaking documents, I'll say no more about that. Lodged documents, Your Honor, I want to lodge the deposition of the petitioner. Don't e-file it. Lodge it in the conventional fashion, but if you have a notice of lodging, absolutely e-file that so everybody knows that you have or intend to lodge it. Judgments and quadros. We saw some questions, oh my God, what happens with judgments on e-filings? How many copies and how do I e-file my return envelopes and things like that? Not to worry. Submit your judgments and quadros in the conventional way. If and when that changes, we'll let you know. Now, what about documents in related cases from the civil division, for example? So a civil complaint and a family law petition are related by Department 1 and sent to a family law judicial officer for handling. They're linked together like railroad cars, and you need to file a document in your civil action for your family law judge. Where do you file it? The answer is in the civil e-filing portal. Civil documents get filed in civil, family law in family, even if the cases are related. Okay, given timing, we are going to move on to slide 23. One back. There you go. Let's see if I have covered all of this. I think given the time that we have, I'm not going to say more. I do want to say we have more information about our guide and file integration for guided interviews and our Modria integration for ODR custody agreements. For those, please watch our longer presentation of October 1. Slide 24. Anna Ruth already said it. I just want to underscore it. in our child support courts, AB1058, 4D, whatever you call them, we will not be receiving those documents by e-filing. They are exempt. So be aware of that. All right, you know what, Abbas? Well, actually, let's go to slide 27, because this is really important. And Anna Ruth has some really important things to say about it.
Okay, I know we're short on time. I do just want to highlight that we've learned through the filings that are submitted in probate as well as in civil that we have some common rejection reasons for electronic filings. And these are highlighted here: incorrect filing fees, incorrect case categories, incorrect case type selected. So these are just the information that you're entering about your filing doesn't match the document, then you will see a rejection come back your way, which you can quickly fix and resubmit to the court. Again, we honor filings through 11:59 p.m. on the same day. So just thought we'd highlight some of these important rejection reasons. The last thing I want to highlight here is the most typical rejection reason is the last one listed here. Actually, multiple documents are submitted as a single PDF. So I just want to say that a document with an exhibit attached, for example, exhibit A to an RFO, may be the same PDF. We would just ask you to bookmark for easy navigation, and that bookmark is equivalent to a tab. Just tab that exhibit A in your electronic document. But documents that are two separate things, like a DV-100 and then a DV-110, which would each receive a file stamp, should be two separate PDFs. So just kind of think of this as the pages that you staple or bind together in paper as one document should be one PDF. And then the tabs or separator sheets that you add for exhibits are bookmarks in the PDF document. That's all I had to say on this. Thank you.
Okay.
I just want to say that if you go after 1 o'clock, it's okay, provided your time permitting. So we're not limited by 1, so we can go 5-10 minutes after that.
Okay, that's great. Thank you for that. I would like to say this. First of all, if your head is spinning and saying, oh my God, what's a hyperlink? You know, oh my God, how do what's a transaction envelope and how is all this going to work? Another resource is talk to your EFSB. You know, go to the list and look at their websites and talk to them. They are your professionals. They're going to be charging you money for this. You can elect various levels, including concierge service. So you're really not on your own trying to figure this out. The last thing I want to say before turning this over for some questions, you're going to need to acquire knowledge and capability in the world of electronic signatures. And maybe you have not yet confronted that. There are court rules on that. There are a lot of resources. This is not a CLE on that. We don't have time to do that, but be aware that you are going to need to understand the rules regarding electronic signatures. I guess that's all I'm going to say about that. Okay, Abbas, I'm not sure how we are about to do what we're about to do, but would you like to pose any questions to us for 5 minutes or so?
Sure. We received about like 70 or so questions, which when I subclassified them, most of the questions could be, one group of questions are about from mediators. They are asking, we are not the attorney of record. Are we the e-filer? Can we file it as agent for a non-represented party? So if you explain to that, this is a group of questions, which is, it will respond to that.
Anna Ruth, you want to take that?
Sure. So the court does not monitor who's actually doing the submission of the filing. What we really care about is that the right person is designated as the filer. So at the time of registering and know that the conformed copies are going back to the registered filer, that's the information that should be provided in both the registration as well as in the information that's entered in the e-filing portal. That said, there's also a field in the portal that allows for additional courtesy copies to be delivered. For example, if an attorney were to register their firm, but then add different staff within the office to also receive conformed copies, they would also receive that conformed copy back from the court. So there is a field where you can enter additional email addresses for receipt of copies in some of those portals.
And boss, before you go to the next question, my friend Gretchen Taylor asked a great question, something close to my heart, about submissions of the FAM 200 stipulation and proposed order to appoint a privately compensated temporary judge. And should those be submitted in paper or electronically? Anna Ruth and I actually talked about that question before this presentation. We are of the view, Commissioner Taylor, that because privately compensated temporary judges by definition are lawyers, currently licensed, that they should be e-filed in. Because they're going to require a signature of the supervising judge, they will be returned to you from the resource account. Bottom line is they're going to get printed here, brought to Department 2, and returned in the conventional fashion. Okay, Abbas.
A series of questions we had about direct filing, whether or not the direct filing will be done from November 15 by the attorneys. And I believe there is one question also, that whether or not the resource account will be open between February and November 15 and February, so the improper can use the resource account to file papers.
Okay, so on the first question about direct filing, I'm not sure if the question is like over the counter type filing, you know, can attorneys file over the counter? There are only few exceptions in which they are not mandated to electronically file per the general order. And that is, for example, the restraining orders can be submitted conventionally or over the counter, via Dropbox, via mail, or electronically, as well as all of the listed exempt documents that we talked about, including judgments, quadros, as additional examples. And then your second question was whether the resource accounts were going to continue to be operational for pro-pers or others to electronically file, and the answer is no. As of November 15th, all electronic filing will be through the e-filing process. No resource accounts and no fax filing will be processed. All of the resources will be diverted to processing e-filing.
And I'd like to comment on that as well. During the COVID crisis, we created email resource accounts for the presentation of restraining order applications and responses and ex parte applications, because we felt we needed to. There were stay-at-home orders and we had no other tool available to us. It's unbelievably labor intensive for us to process papers in that fashion. So while this is unwelcome news to many, we know, we are ceasing the presentation of restraining orders and ex parte applications by email and those resource accounts. All right. Now, there are another collection of resource accounts that we sometimes talk about. Some of our judicial officers have emails that they consent to use to communicate with you all on various ministerial matters. I'm one of them. I tell people all the time, send me dates at LRIF, at my email account. Those resource accounts that the judges maintain and use are unaffected by anything we're talking about here today. What's next, Abbas?
Okay, this question is regarding proper people without an attorney. How they can register for e-filing?
They also would register with an EFSP and then are able to use the e-filing process.
Is there a place that they have to go to, or they have to go to the website if they don't have an attorney and they don't know how they would do that?
Okay, so in many instances, they will either link with our self-help centers or other legal aid providers for assistance, but whether or not they avail themselves to those services, the website, the court public website does have the list of vendors that they can click into and then register and begin the e-filing process.
We have a question with interaction between CRC 2250B6 and 227B with respect to definition of electronic filer and electronic signature, whether an attorney is agent of the client or when they sign, is a filer attorney by himself, by herself or himself, or the filer is the client and his signature, especially on a stipulation or judgment, it should be appeared.
Anna Ruth, do you want to take a swing at that? Okay,
so please know that I'm responding from the administrative right side of this, and an electronic signature for the purpose of filing with the court will be accepted. That said, the validity of that signature is not something that we clerically determine or look at in processing of that e-filing submission. And so I don't, have the legal aspect of validity on this, but an electronic signature is accepted for the purpose of e-filing, and then the rules as to, whether they complied with the CRCs on the format for that electronic signature, whether it's under penalty of perjury or all the other requirements, that is really going to have to be hashed out in the courtroom.
And I'd like to comment.
Your Honor, just one quick thing. Abbas, maybe at this point you should stop the screen share because it's kind of making the things disproportionate. So if you stop your screen share, then we'll be in large size.
Thank you.
Let me just say that I think Anna Ruth's answer on behalf of the clerk's office is exactly right. And what she said is that we are going to accept those electronic signatures. Now, we took some heat on the listserv within the last 10 days for that position. And with respect, I think that heat was unfairly put upon us. And what Anna Ruth is saying and what I am saying is if a litigant or lawyer has a point of view that there is some problem with the e-signature that affects the validity of the document, that needs to go to a judicial officer. That is not for the clerk's office to try to figure out at the front end. That's my view, at least. Okay, can we perhaps have one more question, because at least, well, Anna Ruth and I have some other obligations starting soon.
I am looking at this question and say which one the most difficult one.
Boss, while you're doing that, I just want to throw one quick thing out. You know, Judge Riff, I just want to expand upon the extra resource of going to your attorney service and just point out to everybody that the big advantage of this system over what you're currently doing is that if you send somebody to court from your office to run a document to court, you don't really have a good record to charge and pass through costs to your client. Whereas on this system, when you're using your attorney service, you're going to have detailed records of every transaction. The cost to do the filing is significantly lower. Many of the EFSPs are under $10 per filing, and they're doing the concierge services for between the ones that I've surveyed anywhere from $25 to $35 or $40, which all gets passed through to the typical general client. Yes, I understand the issue with the pro per world, but from a management standpoint, for most of the lawyers watching this, this will be a great assistance to you and will be a lot less work than you're actually anticipating. And where do I come from with that? Many moons ago in a galaxy far, far away, Judge Lewis appointed me to be one of the interface people between the start of the e-filing committees and e-filing. And that was the number one thing from the lawyer's perspective that we have. We understand the complications with pro pers, but from the lawyer's perspective, this will be a much more fluid, much easier system for you once you get it up and running. The end.
This last question I asked, maybe it refers to some tactical time that people file an RFO, but they wait and they don't serve it until gets 21 days before the hearing. The question is just when we file an RFO by e-filing, will the court inform the opposing counsel? Would they have a notice of the paper filed with the court or e-filed with the court?
So we don't, from the court perspective, we don't electronically serve parties for you. Now, you may have made an arrangement with your EFSP to provide electronic service on your behalf. And in that instance, you know, that process would be followed. But we, as a court, do not serve the other parties. The information is just sent back to the filing party as it is today.
So.
Well, yes,
hold on, Abbas, before your closing comments, let me say my closing comments. Number one, friends, please be patient with us. We'll be patient with you as this rolls out. We are all good at being patient with one another. I think we've seen in the past. It's going to be frustrating. There will be some rocks in the road. We know that, you know that. So that's number one. Number two, we are going to look at all the questions submitted to us, and there were a lot, and we will make sure that every one of them is addressed in some fashion in our frequently asked question section on the website. And we encourage you, read it often because we are constantly updating it. Thank you.
And on that note, thank you, Honor. I had a couple of questions with respect to FLAT program that one of the questions is important was, is there a list of 16 programs that we will have? Basically, we have 4 sections of FLAT. Section 1, commencement of the case, which includes filing petition, service of process, response, and your first RFO or TRO. The second section will be discovery, which starts with this declaration of disclosure, paper discovery, discovery by deposition, and e-discovery. The third section is in trial, where we start with pre-trial tactics or logistics. We have a paper trial part of the trial, we have argument of the trial, and we have judgment. And and then for appeal, again, we have the preparation paperwork, argument, judgment and result of the appeal, and also a section about post-appeal, what's going to happen. Further detail will be announced on the website and by our friends on CLE. And on that note, once again, thank you, Your Honor, Judge Riff. Thank you, Ms. Gonzalez. Thank you, my friends on CLE. Thank you, Mr. Mindell and our friends. And thank you, almost 400 of you, which spend the time with us. And we wish you a better and more less trouble practice in the future. Thank you, Your Honor.
Thank you for inviting us. Bye, everybody.
Thank you.